Vodanovic, obviously at Trinity Chambers, and I'm going to talk to you about some property law. So we're going to look at some case law to do with various issues that have been happening over the last year. So when I started looking at what I should talk to you about, there was definitely a trend that was emerging in terms of the cases. There were a lot of nuisance cases that kept popping up. So what I'm going to look at is the private common law nuisance and also definition of nuisance, annoyance, and disturbance in restrictive covenants. A couple of interesting lower courts decisions in relation to that. And then if you've ever dealt with a nuisance case, you'll be aware of the seminal case of Lawrence and Tigers from the Supreme Court 2014. That clarified the position as to how nuisance cases are to be dealt with, it crystallised the legal principles, and not much has rocked the boat, the nuisance boat, since that case. But there are two outstanding Supreme Court decisions that may be coming our way, one definitely coming, we'll see about the other one, which could change that perception a little bit, so I'll look at those as well. And then I'm going to look at a couple of other interesting cases, not to do with nuisance, but generally property law. So, turning to the first one, this is a first instance decision, case of Jones and the MOD, and it's from the High Court. It's fact specific, but it does restate the point of principle about the locality aspect of where is the nuisance happening and the character of the land. So here we're dealing with a piece of land on Anglesey that the Joneses owned. They wanted to develop it to create a holiday and leisure park. They bought it in 2003 and they developed the land a little bit later into that holiday park. But crucially, at the time that they bought it, and indeed before that time, since 1951 in fact, the Mona Airfield, which is only a mile away from their land, was used by the RAF as a relief landing ground for RAF Valley. So the Joneses put their case in nuisance on the basis of an increase in flight operations and therefore the noise since 2007, 4 years after they bought it, because they knew they might have a problem if they were trying to say that at the time they bought it, the noise was just as bad. So they were trying to say it's increased since we bought it. When we bought it, the land was being used for purposes ancillary to the supply of water. They bought it off the water board. So what they were trying to introduce later on was a different use of the land. So they claimed the private law nuisance, it was an actionable nuisance, the increase in noise, but also claimed that their Article 8 rights under the European Convention of Human Rights were infringed. Now, they unfortunately failed to establish on the facts that there'd been an increase in noise, because the evidence that came from the MOD was in the form of high-ranked officers who impressed the judge with the precision and detail that they gave. Mr. Jones and his evidence did do as well compared to them. So the court found that there'd been no increase in the flights and there'd been no change in the flight path either, which is one of the other factors that Mr. Jones wanted to argue. But the judge did say there was noise over the Joneses' land, that was accepted. And the judge definitely gave them that and said it's very loud when it happens. So the noise occurred on weekdays between 8 a.m. and 2 p.m, but it was intermittent and it was not regular. So the locality was extremely important. Where was this actually happening? And this area was largely agricultural. There was a sleepy village nearby. The noise from the aircraft had been present since 1951 when RAF Mona first started being used. So the noise had been part of the environment for generations. And therefore the locality, which was the important factor, meant that the noise was there first. And crucially, the noise on the evidence had not increased. So the intensity of that noise had increased, which meant there was no nuisance created. What the judge also took into account was the wider public interest in training fast jet pilots on this land, carrying out the type of training that could only apparently take place in this country at RAF Mona and RAF Valley. And in addition to that, another really important factor the judge took into account was that the MOD had in fact taken reasonable steps to ensure that the noise was kept to a reasonable minimum. And there was quite a lot of evidence in relation to this, because there had been previous complaints from other residents and they'd taken certain measures to try and reduce it. So all of this fed into that argument. The Article 8 argument also failed. The judge found that the Article 8 argument was engaged, or the article was engaged, so there was an interference with the Joneses' private life, but the judge said the justification aspect, which is the second limb of Article 8, the justification aspect of it was made out because the interference was necessary in the interests of national security, given the activities that were ongoing there. So what this case gives you is nothing new, factual dispute. However, it does restate the case law nicely, and it gives that emphasis on locality, which goes back to Lawrence and Fenn Tigers. So moving on from that case to looking at a restrictive covenant case. So this is a first appeal decision from a circuit judge to the High Court, and it was a permission to appeal hearing, but full arguments were heard on the substance of the appeal. And what they were trying to do there was to try and widen the extent of the test to be adopted in looking at whether or not a restrictive covenant relating to nuisance has been breached. And I've set it out there. There's your restrictive covenant, what it was meant to be doing. So this concerned the residents of a close in Wimbledon. They claimed they had the benefit of a restrictive covenant imposed by way of a building scheme. So all of them had the same covenant, or the benefit of the same covenant. And the alleged nuisance or annoyance was the building of an extension of the Sharps' house. That was the extent of it. So the judge at first instance decided that the extension wouldn't breach the covenant. He said it's the hypothetical reasonable person test that we're going to adopt here, and that test is, would a reasonable person living in the neighbours' houses be annoyed by the proposed extension? And this goes back to the Todd Heagley case of 1888, so we're looking at some pretty established case law. The sole ground of appeal was that that was the wrong test to adopt. And what counsel for all the other residents tried to argue, very hard, was that it should be the range of reactions test, not the binary reasonable test, but reasonable person test. So what they said was perhaps a reasonable person might not be annoyed by the extension, but if there is somebody who would be annoyed, whose views can't be described as unreasonable, then that would still be a breach of covenant. It's a bit of a tenuous argument, perhaps, and it turned an interpretation of the wording of the decision in Todd Heagley. They were taking certain parts of that decision, dissecting them, and trying to find distinctions effectively that didn't exist. So on appeal, Mrs. Justice Bacon didn't have much hesitation in refusing this and restating the test and saying the test is, would a reasonable person, an ordinary sensible person, having regard to the ordinary use of the relevant properties, be annoyed by the activity in question? She effectively said there's nothing within the wording of the covenant which meant that a different test was to be applied, such that it included this range of reactions test. So it was very much rejected by the court. So we're still back to where we are with that test as it was back in 1888. So coming now to the big ones, Supreme Court that I mentioned. So this litigation, this is a Court of Appeal decision, Jalla and Shell International. Permission to appeal has been granted by the Supreme Court on the substantive issue of the timing of the accrual of cause of action in nuisance. So it's potentially a big limitation case in nuisance coming up in terms of the decision, generally for tort too. And this has spawned quite a lot of serious litigation in the High Court, which has then been appealed with various ancillary points. So if you do look for this decision on Lawtel or Westlaw, you will find quite a number of different reported decisions to do with various other, say, satellite litigation, dealing with other parts of limitation, but also group actions. Effectively, about 28,000 residents on the Nigerian coast were affected by this, and this was all stems back to an oil spill in 2019 off the coast of Nigeria from a defective oil pipe. So that oil pipe pumped oil into the sea for about 5 to 6 hours before it was stopped. But obviously, oil being oil in water, the sea being the sea, it kept spreading, and it kept then hitting the coastline much later. So the damage continued to be caused much after the time of the actual accrual of the cause of action. So the Court of Appeal determined that the continuing presence of the oil many years later was not a continuing nuisance, but merely the continuation of damage. The pipeline being turned off and the nuisance was abated. So the argument that was advanced in the Court of Appeal was that a single spill could give rise to a fresh cause of action every day that the oil remained on land. But the Court of Appeal said, no, the presence of the oil has nothing to do with the time at which a cause of action in common law accrued to the appellants. So nuisance and physical damage or harm were not the same. And they said it's even debatable whether physical damage is an ingredient of nuisance. So the authorities were clear, as far as the Court of Appeal was concerned, that a continuing event or hazard was needed for a continuing nuisance to be present. And in this case, the hazard was the defective oil pipe. It ceased to be a continuing one when they turned the oil off and fixed the oil pipe. So they carried on saying that the continuing damage that kept being caused was not the same as the hazard. And if that argument were to be accepted, the ramifications of that could be quite significant for the future, and not knowing when any future liabilities might stop. What they also try to argue is that the nature of the spill being oil and its properties and how it spreads, etc., and then how it ends up on land and how it ends up causing damage were very specific factors in this litigation that had to be taken into account. But that wasn't successful either. So as I say, permission to appeal to the Supreme Court on this substantive issue was granted in May 2022, so this year, so I will watch this space for that decision coming out. Now, the second biggie, if I can call it that, is the Tate Modern case. You might have heard about this back in 2020, a block of very expensive high-rise flats built next to the Tate Modern and their new viewing platform at the very top of the building. These flats had winter gardens, and these are floor-to-ceiling glass structures which are put on the end of these very expensive flats. They were meant to be used as gardens, but the residents effectively integrated them into their living space, so they were being used as part of the flat. So tourists or visitors to the Tate Modern then, top of the building, had a pretty good view into the flats anyway, given that these were high-rise, but also had a very good view into these glass structures, and apparently tended to peek in with binoculars quite a lot. So the residents sought an injunction to close that part of the viewing platform on the basis that it caused them a nuisance. But they also argued that this infringed their rights under Article 8, right to private life. On the nuisance point, the Court of Appeal said there's no authority in support of the proposition that mere overlooking amounts to a private nuisance. So the Court of Appeal was not prepared to develop the common law to such an extent that it extended nuisance to overlooking, and in particular they thought, why should they when there are planning controls and laws, and that can deal with that aspect of it. They said this is more to do with invasion of privacy rather than damage to interests in property. So they preferred to leave it to Parliament to make this leap that was argued for, rather than attempt to shoehorn it into the law of private nuisance. So they dismissed the private nuisance aspect of it. As to the application of Article 8, this is where it gets a little trickier and a little less clear to my mind when I read this judgment. So the Court of Appeal said the court at first instance should have asked itself first whether the common law of nuisance extended to overlooking. If it didn't, only then should the court have asked itself if there was an infringement of Article 8. So the court was saying the court should have asked itself whether Article 8 provided justification for the extension of law of private nuisance to overlooking. And the court should have done that of its own accord because the court is a public authority and has a duty to consider Article 8 or any other human rights because of Section 6 of the Human Rights Act. But in this case, they said the judge at first instance never made a finding of an infringement of Article 8 because, in effect, he found that in all the circumstances, the appellants didn't have a reasonable expectation of privacy in the absence of the protective measures which he considered they ought reasonably to have taken. So I think what he's saying is they should have put some stuff up to protect themselves in terms of the invasion of privacy. Because they didn't do that, they couldn't have a reasonable expectation of privacy. So the Court of Appeal said it didn't really matter in the end on this Article 8 point. So what they said was that the Article 8 wasn't engaged, in fact, so they didn't even get to the justification aspect of it, looking at whether it was justified or not. And contrast that with that earlier case I was talking about of Jones, where it was accepted, there was a privacy issue or a breach of Article 8, but it was justified under national security in the case of Jones. So there were a number of problems identified by the Court of Appeal also with trying to use the Article 8 as the route to this extension of the private law. They said Strasbourg's not given us any authority on this, and also it would distort the law of tort itself, because nuisance applies only to those who have proprietary rights, whereas if you put this under Article 8, it would then apply to everybody without any proprietary rights. So therein lies this tension, this difficulty. The Supreme Court judgment is awaited. Full argument was heard in early December last year. I was rather hoping the judgment might be handed down by today, but it hasn't been, and there's no date set, but it should be coming out shortly. So one to look out for, I would say, in relation to nuisance. So moving away from nuisance and covering some other aspects of what's been going on, we were talking about restrictive covenants earlier. This case concerns a restrictive covenant to do with effectively nuisance or annoyance being caused or prejudicially affecting adjoining premises or the neighbourhood. But this is to do whether the restrictive covenant is in fact enforceable or not. The residents, so Bath Rugby Club was trying to convert the recreational ground that they own, trying to build a stadium on it. Mr. Greenwood said, I'm going to be affected by that because I overlook it. And he tried to claim the benefit of this restrictive covenant in a 1922 conveyance that neither party was the original party to. But he was claiming it by annexation. And therefore, the land that was to have the benefit of the covenant had to be identifiable. And this is what the Court of Appeal was looking at, whether that meant that the land was sufficiently identifiable to allow the covenant to bite. And the Court of Appeal decided ultimately that the critical question was this: whether there is manifested in the conveyancing documents, construed in the light of the surrounding circumstances, an intention to benefit certain land. And they said there was nothing to identify the land that was to be benefited, and the words adjoining premises or the neighbourhood were insufficient. There weren't any adjoining premises really that could be identified, and the neighbourhood in particular was a very wide concept. So Bath Rugby Club, having applied for a declaration under Section 84(1) of the Law of Property Act, it wasn't bound by this restrictive covenant, was ultimately successful. And then very lastly, this is an interesting access order case. So apparently this is the first time the High Court has considered an application under the Access to Neighbouring Land Act 1992. So it's of some significance because it deals with how these applications should be dealt with in practice. So a lot of the judgment is very fact specific, but the case got this far because what we're dealing with here are two big developments. We're talking super prime properties, London, South Kensington. Each development was worth 50 to 75 million. They were initially getting on, the owners and the workmen, but obviously relations soured, they'd fallen out, they distrusted each other, and it necessitated an application to the court. So there are competing interests at play here because you've got two developments going on side by side. If you allow access to one onto the other land, it stops the work in relation to part of that development. But if you don't allow access to the party asking for it, they can't do the works that they need to do. So there was a lot to consider. The defendant raised a lot of objections to the proposals. They claimed a lot in terms of compensation. The court didn't have much difficulty in rejecting the amounts that were claimed. But it ultimately granted the application for the access order, which said those works need reasonably doing. When they are to be done, are they immediately necessary or not? That was an interesting point, and the court said, well, no, they're not immediately necessary, so I make the access order, but I'm going to move the date when you do it to a time that's more convenient. And in deciding this, the court considered, is the disturbance such that it's unreasonable for the court to make the order? And that's where those competing interests were balanced. So if you're dealing with an application such as this is the case to go to, because it will give you practical guidance. But what's really interesting to note from reading this judgment is a warning given by the court as to how the parties are expected to behave before they come to court, but also during their arguments and how they're presenting their arguments to the court. And what the High Court judge said was where the defendant makes legitimate objections to the proposal, the court has to consider how those objections can be mitigated through the terms of the order. And both parties should try to assist the court in doing so. So the defendants are expected to work constructively with the claimants to see how any detriment can be lessened. And a defendant who fails to engage risks losing the sympathy of the court and risks cost consequences. So you can tell that the court was getting somewhat exasperated by the approach of the parties, and they got a bit of a telling off. But it is a warning and something to be borne in mind when such applications are made. There were then useful comments made in relation to compensation. Arguments that were made by the defenders say that they claimed a lot, but the court went on to, even though dismissing it, went on to give guidance as to how this should be interpreted. So we're looking at license fees, consideration, the Act, and all those points. So again, useful to bear in mind if you're looking at the quantification of this as well.